tribunals are also judicial or quasi-judicial bodies. And these judicial or quasi-judicial bodies have to be independent. And therefore they said that, therefore, the rules made by the government, which essentially exclude the judiciary from the selection of the members of these tribunals, are ultra vires. The government repeatedly tried to again bring the rules, again and again, my lord, they were struck down finally by a constitution bench of this court. So I am relying upon 5 constitutions. Anup Baranwal is one which deals directly with the appointment of the election commissioner, but 4 other judgments which deal with judicial or quasi-judicial bodies, and all of which say that, look, an election commission is clearly a quasi-judicial body, clearly. It decides so many important disputes, etc. Symbols, so many things. So therefore, in each case, the principle laid down is the same, that the independence of such a body is absolutely essential, of a judicial or a quasi-judicial body is absolutely essential. In order to comport with the rule of law, in order to comport with Article 14, it is absolutely essential. And therefore, you cannot, and independence is not ensured only by the fact that removal can only be done by impeachment. Independence cannot be ensured only by that. Each of these judgments are effectively to that effect. That for ensuring independence, you also have to ensure that the appointment is not dominated or controlled by a party which is one of the parties to the disputes. In this case, my lord, the government or the ruling party is clearly a party in elections, clearly the most important stakeholder in elections. And that's what Anup Baranwal, the principle in Anup Baranwal is laid down. That, and now you bring a law which effectively nullifies that principle. My lord, I can understand. You can certainly bring in a law, but you cannot bring in a law which violates the foundation on which that judgment is rendered. Same thing happened in PUCL and ADR. In ADR, my lord, the Supreme Court directed that for comporting with Article 19(1)(a) rights of the voters, they need to know the criminal antecedents and assets and liabilities of candidates. Now the parliament brought a law to effectively say that no, all that information, only this part of the information may be given. So the court struck it down on 2 grounds, essentially on 2 grounds. First, they said that, look, you have, and you cannot alter the basis of that judgment because that judgment is based on Article 19(1)(a) rights. Just as Anup Baranwal is based on Article 14 and democracy and 324. So, in fact, my lord, even if they had brought a constitution amendment to nullify this, in my respectful submission, I am now arguing contrary to what Mr. Hansaria had argued. It would have violated the basic structure of the constitution because just as, my lord, in that NJAC case, the Supreme Court struck down that constitutional amendment that it violates the basic structure. And there it was not dominant control. In that NJAC, they struck it down only on the ground that the executive can significantly interfere in the process of appointment. They didn't have dominant control. Here, clearly, my lord, they have dominant control. Clearly, Prime Minister, one minister appointed, and my lord, we have seen from experience that in every case, the opposition leader dissents and his dissent is ignored, and the person that the Prime Minister and his other ministers select are appointed. So therefore, my lord, in my respectful submission, this case is squarely covered by these at least 5 constitution bench judgments. And now I'll read out, my lord, the passages, the relevant passages. Now, I won't read out all the passages that I have quoted. It's a fairly detailed submission. Now, Your Lordship may turn to the second page, para 6. The Constitution Bench of this court in Anup Baranwal, after observing in the unique nature of the provision we are concerned with and the devastating effect of continuing to leave appointments in the sole hands of the executive on fundamental values as also fundamental rights, we are of the considered view that the time is ripe for the court to lay down norms. And there they held, number one, that the members of the Constituent Assembly, Fundamental Rights Subcommittee, Drafting Committee were of the clear view that elections must be conducted by an independent commission and that the appointment of the Election Commission not be made by the executive alone. 2. Founding fathers inserted the words subject to the provisions of any law to be made by Parliament as they wanted Parliament to make a law under Article 324 of the Constitution of India. Pausing here for a moment, my lord. Not only make a law, but make a law in which the dominant voice cannot be of the executive. It will be an independent selection committee. Then 3, there is a vacuum as no law has been made by Parliament under 324. Political parties have not come up with the law, as there is a crucial link between the independence of the Election Commission and the pursuit of power. What has been happening was, my lord, that the court has noted that while in opposition, they say that there needs to be an independent appointment body. Once they come to power, they forget about all that. But because once they come to power, they feel now we will exercise our control. This is what had been happening over the years. And that is why, my lord, Mr. Advani had raised this issue. So many, when people were in the opposition, they raised that issue. Goswami committee went into it, Law Commission went into it, etc. And they all said this had been agitating the people for a very long time. But unfortunately, every successive government was just continuing that. It suited whoever was in power. 4, the Election Commission of India has been charged with the extraordinary power to hold elections to both Parliament and state legislature. Power under 324 is plenary, and Election Commission also discharges quasi-judicial functions. 5, election commissioners, including Chief Election Commissioner, who have infinite power and have to uphold fundamental rights and rule of law, should not be chosen solely by the executive. An independent person and not a yes man should be appointed as a member of the Election Commission. Leaving this power of appointment purely and essentially to the executive destroys the independence of the Election Commission. It is necessary that the Election Commission should be insulated from executive interference and the purpose of independence in the functioning of the Election Commission. And then they said that the court has the power to fill a vacuum under Article 142, and therefore directed that the appointment of the election commissioners should be like this till an appropriate law is made by Parliament. But appropriate law didn't mean, my lord, any law. Appropriate law, you cannot make a law which brings back the same defect which the court had clearly underlined, repeatedly underlined in their judgment, which is premised on democracy, free and fair elections, democracy, and Article 14 and the rule of law. The requirement of having independent election commissioners is premised on all those principles. And therefore, just because the court said that, all right, we are making these directions subject to any law being made by Parliament, doesn't mean that they can make any law. Then, my lord, the relevant paras, and I have quoted, I won't read all of them.
Parliament so long?
Yes.
What happened before Barnwal? Why did the Parliament not make a law? 324 is clear.
Same thing, my lord. That every time that a government came to power, they felt that now they can misuse this power of appointment. So therefore, and that is noted in this judgment in Baranwal also, that while in opposition, people were clamoring that there should be an independent body. As soon as they came to power, my lord, they stopped bothering about that. This is what was happening. And that is why the court had to step in. So,
I'm reminded of a parliamentarian saying,
yes,
tyranny of the unelected. This should be equated with tyranny of the elected.
yes, yes, yes.
Tyranny of the majority.
Tyranny of the majority today. That is why, my lord, there are fundamental rights. That is why we have a constitution. That is why we have a republic. That it cannot be the tyranny of the majority also. It has to be
Whoever comes in power is
doing the same thing. This is unfortunate, my lord. But
unfortunate for our country.
yes, it is very unfortunate. Very unfortunate.
You know,
And that is what-
just about 2 days back, I had the occasion, to see a video
Yes,
prepared by BBC.
yes.
Need to hear what Dr. Ambedkar said.
No, Dr. Ambedkar
He
was
was a dejected man.
very.
He was a
remarkable-
dejected man in 1953.
Yes, yes, my lord. He was a very deep thinker, absolutely astounding person. Absolutely, and absolutely the right person to shepherd the constitution. Absolutely. That is why, my lord, we got a fairly good constitution. I'm not saying that the constitution has no problem whatsoever, but at that time, my lord, to make such a constitution was a gigantic feat in this country. And even to hold elections was a gigantic feat in this country. But it was done. It was done.
Within 3 years of the constitution, he felt that democracy is not working in this country.
The Constitution First Amendment Act, when which was challenged, Dr. Ambedkar appeared and challenged that act. He appeared as a counsel after resigning as a law minister.
Now, of course, my lord, we can see many problems which have erupted, many problems which have erupted. And this is one of the problems that this court, my lord, took pains to try and set right. It's a detailed judgment of 5 judges of this court. They took great pains to say, to write down the whole history of this, of the Constituent Assembly debates, the Law Commission, the Goswami Committee, this, that, and the other. And thereafter, my lord, they have analyzed the importance of free and fair elections in a democracy, the role played by the Election Commission. And thereafter, they have said that, look, the independence is essential, but it cannot be secured merely by the fact that removal is by impeachment. That's not the only way that you can secure independence. And that is why you need an independent selection committee. It cannot be dominated only by one party, which is a party to the elections.